The writ petition is dismissed. However, taking a holistic view, the order dated 15/9/2017 is modified by dispensing the requirement of personal appearance with the officers of the petitioner. Considering that the petitioner bank is a public sector bank, the cost imposed by the Leonard DRT Guwahati is also reduced to ₹25,000. Petitioner is, however, directed to comply with the other aspects of the order passed by the DRT on 28/8/2014, which has attained finality on dismissal of the appeal by order dated 4/7/2017. Interim order accordingly stands merged with the final order.
Submitted assignment in this letter, item number 15 mail. But today I have some personal difficulties. I matter may kindly be confident of
2018 matter.
Yes,
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
My opinion, Your Lordship. I may be allowed to move.
15.
I may be allowed to move a habeas corpus petition today itself, Lordship. It is filed today.
What is the matter?
Lordship, my wife has been kidnapped, Lordship, and accordingly,
Wife has been
kidnapped,
kidnapped.
and accordingly, I filed an FIR before the officers in such Bahadasari police station. Accordingly, I was summoned, and the kidnapper and my wife also summoned. But without registering the affair, my wife has been handed over to the kidnapper, and he now taken her away from Madras, Lordship. The case was not registered. Her statement was not recorded before the magistrate, Lordship. I have annexed the affair, Lordship.
Okay, strange. Okay.
Lordship, much.
May I please, Lordship? Lordship, I beg to mention item number 6, Lordship. But the matter may be adjourned for today, Lordship.
On a request, same on behalf of the petitioner. Next week, 1 week. Let him see. Yes.
May it please, Your Lordship. Lordship, I beg to mention item number 25, Your Lordship. Yesterday, I have submitted adjournment slip, Your Lordship. Lordship, the arguing counsel had some personal difficulties, Lordship.
Okay, same 1 week, no? 25.
Highly obliged.
I beg to mention item number 31, Lordship.
Hmm.
Lordship, conducting counsel Mr. N. Hasan is out of station, Lordship. Adjournment has been submitted, Lordship.
Review against which order?
Actually,
Review against order of this court? Perhaps not.
yes, Lordship.
Huh?
Yes, Lord.
This bench has not sit together. How can it be a review of this court?
Should be
Okay, after a week, huh? Same
after the
1 week. Yes.
May I please, Lordship? I beg to mention item number 16, Lordship. Yesterday, I submitted adjournment slip, Lordship.
Again, 18 matter. Why are you seeking time?
Lordship, somehow misplaced the file, Lordship. 1 week time.
No, those are excuses will not accept. Next week, come prepared. Same, huh? 1 week.
Lordship.
May I please, Lordship, I beg to item number, Lordship, 14, Lordship. Can I agenda matter for a day?
14, 1-4.
Yeah, yes, Lordship.
Again,
14.
18 matter. Why are you seeking time?
Lordship, engage counsel, they are out of station, Lordship.
Who's the engaged counsel?
P. Baspar and B. Sarkar, Lordship.
Okay. 8 to 14, 1 week.
Please.
May I please, Lordship? I beg to mention for listing of foreign tribunal matters, Lordship.
Matter at what stage?
Lordship, last posting, Lordship,
What is the
15th
stage of the matter?
admission matter.
Admission. Matter of which year?
No, Malaysia.
Matter of which year? What is the year of filing?
2025, Lordship.
25. Last listed when?
15/7, Lordship.
What happened on 15/7?
Listed after 4 weeks, till date not listed.
Okay, on Monday next.
Like,
My lordship, in this case, petitioner's wife has filed this case, my lordship. What happened, my lordship? Petitioner was declared as foreigner, my lordship. But before that, my lordship,
Yes.
before he was in detention camp, my lordship. During the filing of this case, before that also, my lordship, kindly come to page 3, my lordship. Page 6, my lordship.
Hmm.
What happened, my lordship, during the COVID-19, my lordship, he was released on bail, my lordship. The person who were been in detention for 3 or more than 3 years, during that time, he was released on bail, my lordship. And after that, he was regularly been, my lordship, before the police station, my lordship, giving his attendance. Kindly come to page 7, paragraph
Yes,
4,
yes,
my
we
lordship.
have records have come. Was the records, where the records call for? Main page issue.
I also filed one additional affidavit.
1534 is filed by you, they are connected with petition.
Yes, my lordship.
We can have both these listed together.
My lordship, there is one problem is there, my lordship. I have filed one IA, my lordship, to bring that his sister has been declared as Indian by the same tribunal. That is remaining defective, my lordship. So I have corrected it down. If it's come, then
We will have all the case together,
at 2.
not at 2 o'clock, next week, next Monday or Tuesday, whenever.
Okay, my lordship, can it be on 17
Wednesday,
Wednesday?
it can be done. 17 is. What is your name? Date?
TK, my lordship.
Sri TK, the learned counsel for the petitioner, has submitted that there is a connected writ petition being WPC 1534 of 2019. He has also informed that in this case, an IA has been filed.
1534, I has been filed, my lordship.
IA has been filed being IA number 1534. Is
No,
it
no,
number
no,
the same number?
no, it's not 1534.
IA has been filed, which however was lying defective, and the said defect has been rectified.
Rectifying, my lordship.
And the said defect is being rectified. Puts the para. List this case along with WPC so and so, and the IA mentioned above on Wednesday.
Deeply obliged.
Yes.
May I please, Lordship, this matter is related with a missing girl. Later on, the petitioner came to know that she was kidnapped, Your Lordship. Your Lordship, the FIR was lost by the petitioner. Petitioner is the father, Your Lordship, and the child is aged 15 years, just completed in the months of June 2025, Lordship. Your Lordship, this FI was lost, which is at page number page number 33, Lordship.
What is the age of your daughter?
The age of the daughter is 15 years completed, and her date of birth is, Your Lordship,
Yes, Mr. Sharma.
5/6/2010, Lordship.
We take instructions.
I'll take instructions.
We'll have this on when? Wednesday or Monday even.
Next.
Your Lordship, I want to apprise the facts, Your Lordship. The kidnapped girl is pregnant in the meantime.
We are aware of those.
Yes, Lordship.
We are aware of those.
Lordship.
You take instructions.
And there was a clear cut of negligence on the part of the investigative officer
What is
because
your name?
my name is Advocate M.K. Shah, Lordship.
Okay, sir. Honorary M.K. Shah, learned counsel for the petitioner who has filed this petition in connection with we can file this petition making an allegation that his minor daughter was kidnapped by the respondent number 6, whereafter an FIR was lodged on 7/7/2025.
Lordship, but it was registered on 9/7/2025 after 2 days.
Let us dictate the order.
Yes, sorry. Lord.
7/7/25 before the Horlomuk PS, which was registered as Horlomuk PS case number 111 of 2025 under section 6 of the POCSO Act on 9/7/2025. Full stop.
No, Lordship, may I submit your Lordship?
Yes.
Initially, it was registered under say 96 and 35 of BNS Act, Lordship. Later on, section 6 had been added, your Lordship.
Under certain provisions of the BNS 2003 and subsequently, section 6 of the POCSO Act has been
Lordship.
added. Full stop. The petitioner has contended that he had gone to the village of the respondent number 6 and 7 and could bring back the minor girl with him to Guwahati. Full stop. Guwahati and had produced her before the Bhordmukh PS. Full stop. However, the minor girl was pregnant, and thereafter the respondent number 6 had again enticed her and taken her back to where? To the village
To the
at
village,
Samastipur district in the state of Bihar. Full stop. Para. Let instructions be obtained by SP Sharma, learned State Council.
No, additional senior government.
Central-
Additional senior government.
Additional Senior Government Advocate, State of Assam. Full stop. To facilitate Shri Sharma to obtain the instructions, let a copy of this petition be served upon him. Full stop. Specific instructions are required to be taken on the steps taken by the concerned PS regarding the case registered by the petitioner. Full stop. List on Wednesday.
Lordship, can it be on Friday, Lordship? Because
Next Friday.
It's coming Friday, Lordship.
Lordship.
Day after tomorrow is a holiday.
No, holiday.
It's a Monday, Lordship.
Next, no, Wednesday, my lord. It is.
You do, it's a habeas corpus day. Monday is also possible.
No.
Take instructions. It's just a WT is required to Bhordmukh PS. It's not so difficult.
No, order is required.
Order will get it by 2 o'clock.
2 o'clock.
When do you want? Monday?
Monday, Lordship.
On Monday. Huh?
Deeply obliged, Lordship.
Monday, 15th. You give an extra copy to Mr. Sharma.
Lordship. I will.
When it's matter, other than the order impugn, nothing was being annexed, your lordship. We are skipping time on the prior date, your lordship. So the documents and the other like document may be part of record of the application. Seeking just a week time, your lordship. Bring all the records, all the relevant documents which was being relied and also the written statement, because the beyond the written statement, nothing will be heard by the Senate.
But 17 order you're challenging now. Why? How do you explain? 17 order after 8 years.
Let us answer your.
Where are you? Where are you? Are you in detention camp?
No.
You don't appear to be in a detention camp.
Arrest, Mr. Gawan. No, not being arrested.
Part 3 RP Hazarika Learned Counsel for the petitioner who has put to challenge an order oblique opinion dated 28/3/2017 passed by the so-and-so Foreigners Tribunal in FT case number so-and-so. By the impugned order, the petitioner has been declared as foreigner. Let notice be issued. Returnable by 6 weeks. 3. G. Sharma for First Union of India, who's there, Home Affairs. Amdas on behalf of SK 84 Then Home Department, State of Assam.
2, 3,
G.
and
Sharma
6,
for
Lordship.
2, 3,
And 6.
5,
7 may be
6.
strike of Lordship.
and 5, 6, 7 also.
7 may be strike of Lordship. Member Foreigners Tribunal.
But normally somebody appears FT, there's an FT council, I think.
Yes, for only on behalf of Home and Political B Department, Lordship. For
Okay,
should not be a necessary party, Lordship. Member for an tribunal.
six. Dubey, anyone for Dubey? On behalf of? ECI is not there. Four is State Election Commission, I think.
Yes, yes.
State election, RW 4, huh? Extra copies. At this stage, notice is not required to be sent to respond number 7. Para, call for the records. List after 6 weeks.
Maintainability may be kept up.
See, these are matters, delay may not be, will not decide there is no interim prayer as such. We are not granting. He is entitled to challenge. This is a very major decision of declaring somebody foreigner.
Yes.
Delay may not be, and may not come into the way. For an interim prayer, yes, delay might be an important factor, relevant factor. But one will be entitled to challenge.
Yes, Lord.
You've got the instructions
Yes, Lordship.
regarding annexure A.
Yes, Lordship.
Is it authentic?
There are
No, Lordship.
Not
no
authentic.
such cases pending in the tribunal. On last occasion, they have submitted. But issue is that then who has issued the notice?
Yes, Lordship.
notice is
No record has been signed, Lordship.
But
In this regard, this is the earlier I have placed this instruction, Lordship.
You put this on by way of an affidavit.
Lordship.
You were given time in fact to file affidavit.
Yes.
Then he'll be also in a position to apprise his client.
Lordship.
And it will be a part of the records. But Mr. Mazumdar, you should take instructions from your client, advise him before coming to the court. Okay. Third, Sri F.Z. Mazumdar, learned counsel for the petitioner. Sri G. Sharma, learned counsel for the respondents, has however submitted that instructions have been received as per which
Take an affidavit, you know.
the notice, as per which, no notice
Yes.
has been issued to the petitioner, and the so-called notice in annexure A is not authentic. We can close this actually. We can
Yes,
record it.
Lord.
Lordship, it can be closed by referring
No,
the instructions.
The copy of the written instructions have been placed before us, which we have produced. Full stop. The said instructions dated 11/8/2025 clearly states that the notice annexed to the writ petition is a forged one and was not issued by the tribunal. Full stop. Para. In view of the efforts and submission and the written instructions, we are of the view there is no requirement to continue any further with this writ petition, and accordingly the same is closed. The written instructions are made part of the records.
Lordship.
Item 5.
Wait, please, Lord. My lords, the imperial order is at page 32, Lordship. 32 to 35, Lordship. The petitioner relied upon 9 exhibited documents, Lordship, to substantiate her claim that She is the lineal descendant of the bona fide citizen of India, Your Lordship.
2018.
2018, Your Lordship.
What is the stage now?
Says, Your Lordship, uh,
Same,
have
same
come-
order. Huh? Issue notice pehla wala. Call for records. Who will accept notice? Union of India? Muhammad Fahd, this, I'm the SKMG, para 1, huh? Then, 2, 3, 4. 2, 3, 4,
2, 2, 4 and 6, Lordship, myself is appearing.
2, 4 and 6.
2, 4 and 6.
Now what about 3, district magistrate?
Yes, I'm.
Yes, 2, 3,
2,
4.
I am appearing, Lordship.
Huh?
2, I am appearing, Lordship. Commissioner.
Okay, G Sharma, 3, 4, would
3,
be,
I am
What about
appearing
4?
for 2, 4 and 6, Lordship.
you're appearing for 2, 4 and 6,
Yes,
G Sharma. 3, P Sharma, huh? Additional senior advocate. And 5, M Kulita, on behalf of P Bura, Miss P Bura for Election Commission of India, 5, extra copies. Yes.
some protection.
No,
After you come, after how many years? Then you were seeking protection. Yes. I did say that.
May I please, Your Lordship? Lordship, impugn order is at case number 37, Your Lordship. Your Lordship, my apology, it is 37, Your Lordship. It is 16 meter, Your Lordship, 2016, Your Lordship. But I failed to submit or plead the grounds of delay of approaching this honorable court, Your Lordship.
Okay, well, issue notice, same,
Lordship, Lordship.
same order. You may be entitled to challenge it, but you have to put grounds actually.
I have filed additional.
What does
application.
having adverse effect? Yes, okay. Note third party right. Who's there? For Union of India, again, M. Das, Madam, for SKMG. Election Commission of India, M. Kulita, on behalf of Miss P. Borwa, huh? 2. Then state over some, Home Department, yes.
yes,
Mr.
Lordship,
Sharma.
3, 7 and 8. Yes,
3, 7 and 8.
Lordship.
Chief Election Officer, Electoral of 2, 4, 5. You're for 6 also, I think. Okay.
6,
4, 5, I think are Dubey. 2 and 4. Chief Election Commissioner will be appearing. What about the Electoral Registration Officer?
ERO, Lordship.
ERO you'll take. Then P. Sharma 4, 5 and 6. हो गया ना सर आपके लिए total 1 to 8 हो गया सर okay extra copies call for the records huh? Extra copies
Yes, please, Lordship. My lord, I am also after 6 years, my lord. Please notice, my lord.
you'll be lucky that notices are being issued. For 6 years you have accepted the opinion and you're suddenly coming to a writ court. Yes, same notice, huh? K.U. Ahmed. Union of India, Madam M. Das on behalf of SK Medhi, Election Commission of India, M. Kolita on behalf of Miss P. Borwa for 2. Then Home Department 3,
3, 4, 5.
3, 4 and 5. G. Sharma. 6 is by P. Sharma. Additional senior extra copies. Call for the records of score extra.
Obliged.
Yes. Ultimately, from the concerned tribunal, raised to take.
Petition to do.
Item
May
number?
please, your lordship. My lord, here in this case, my lord, the petitioner has been earlier declared as not foreigner. Subsequently, there has been another proceeding against her and notice was issued. After receiving the notice, petition was filed taking the plea of red judicata. And in that petition, the learned tribunal has passed order, that is impugn order dated 26/2025 at page 70.
What is the order of 26?
At page 72, so the learned tribunal has held that filing petition for taking the plea of red judicata is an abuse of process of court.
Yes. Mr. Sharma?
Yes, Lordship, during the time of evidence, Lordship, that petition has been filed, Lordship.
My lord.
But what about the settled law now?
Res judicata is
Judgment of the
applicable.
Supreme Court, my lord.
Just a minute.
Taravanu case.
Just a minute, just a minute. Yes, what about this appeal?
Yes, Lordship, res judicata is applicable. If he is same person, Lordship, then res judicata is applicable. But he has to prove that he is the same person, against whom both the reference has been initiated, Lordship.
Are you raising the dispute that the reference in the earlier reference was not pertaining to this present petitioner? Is there anything?
I have not gone through the whole petition, but Lordship, law is that during the time of evidence that petition has been filed, and Lordship, I think Lordship, they have not pleaded that there is another proceeding by which learned tribunal has declared the petitioner as not a foreigner, Lordship. That was not, I think, not pleaded, Lordship, because all this has come before filing of evidence, Lordship. At the time of filing of the evidence, Lordship.
Let us see the order.
My lord, at page 72.
72.
72. Annexure 17 starts from 17.
Please read.
My lord. Order dated 26/2025. Today the case is fixed for evidence of copy. The earlier learned engaged advocate Mr. MD S. Ali moved a petition by so and so for withdrawal of his name from the Ukalatnama. In the petition, the party is put to notice as after the withdrawal of the Ukalatnama, the party is present in person with another newly engaged advocate, Mr. D. Syed, who appeared with duly filing Ukalatnama authorized by OP. The pair of withdrawal from the Ukalatnama by the earlier engaged advocate Muhammad S. Ali is allowed. The newly engaged advocate Mr. D. Syed moved a petition by number so-and-so, that is also praying for quashing drop of the present proceeding as the same is barred by principle of res judicata in the petition. Whereas the order sheet, the earlier learned counsel advocate have already filed the WS on so-and-so in the written statement submitted to OP. Already the plea of res judicata have been taken. The present petition is the same plea already taken in the written statement and it.
No, whether you are the same person.
Yes, my
That
lord.
has to be proved.
Yes, my lord. No, my lord, I have earlier declared not foreigner, and after receiving the notice, my previous lawyer has filed a petition. That petition for taking the plea of res judicata was not accepted, returned by the learned tribunal. Then, my lord, the petitioner has engaged another lawyer and filed this present petition. In the meantime,
in your written statement, you have taken the plea of res judicata. You prove it.
My lord, I should prove, my lord, why I have filed WS taking the plea because of the tribunal has pressurized me that you file WS. Return your petition.
So you have to go by the procedure prescribed by law. You have taken a plea of res judicata. Correct? Res judicata in what sense? That it is against the same person, the same proceeding. There is no dispute to the proposition of res judicata application. But you have to prove that you are the same person. How do you prove?
My
you
lord,
prove it at the time of evidence.
My lord, the proof, my lord, to prove the same person, that can be done by
My lord, looking into the documents, earlier judgment and the documents annexed in the
Those are not required to be proved.
no, not required to be good. My lord, the Taramanu case, my lord. That
Sikdar, it's a slightly different. A point of law being decided between the same parties in the same, that's a de jure. Now here the question is whether you are the same proceeding.
I am not, the petitioner is not required to prove. It is they are to take the plea that this is not the same person. The learned tribunal relied upon a judgment, case of so.
See, if you are raising the issue of res judicata, can you deter will the onus lie upon them? This is your defense.
No, my lord. I have been declared as a not for a man once. Then if they are disputing that the judgment is not correct, then they are to challenge it before the High Court by way of writ petition.
Mr. Sikdar,
In the light of the Abdul Quddus case,
you are on a different. They are not. It's not a question of challenging. See, you are saying that there was a proceeding earlier against me by which I have been declared as an Indian citizen. Now that is your statement. Then therefore the principles of res judicata would be applicable. Now whether you are the same person, there has to be some proof.
My lord,
it can be done in a preliminary manner, preliminary issue also. What is the difficulty?
my lord, that we have.
Just a minute. Not always because the principles like in civil case. Proceeding is concerned. Not at the points of law. Not even point privilege. Three points. And up to him. It's not the correct name. This is the correct approach in any civil matter. When you take a rectification, support him. When you know, speaking, go ahead and not the same thing. So, how is this sympathy? How do you prove? You have to take into the not an limitation. Then into the time the same question. This is the part the documents in this case, these are the same documents. This is whatever. Mr. Singer,
My lord.
the tribunal has referred and relied upon a judgment of this court on the issue
My lord.
of Jahir Ali. Have you gone through the judgment?
Yes, my lord.
What does it say?
My lord, that case is little different. The second case, the petitioner did not raise the res judicata, and it was res judicata point has been raised in the High Court when we filed this declaration in the second proceeding. Then this honorable court has passed order remanding the matter to verify.
Mr. Sikdar,
verify.
whether you take up the defense of res judicata in the original proceeding or in the High Court, this is a defense which you need to establish. It is not on any issues to be decided. Issues have been decided, no problem. The only requirement is whether that person, that proceeding and your client is the same person.
My lord, yes, my lord, I agree.
For that, will documents be enough? You have to go to the
My lord,
process.
no, my lord, evidence is not required, my lord.
Then how do you
Who will be the best to decide the person is one and same or not? I think that will be done by the better the superintendent police border. not the tribunal. And tribunal is taking a view that he should prove again. He is to lead evidence. That is not, my lord. That is not, my lord.
Mr. Sikdar, evidence is not on the aspect of your defense.
My lord.
So far as defense is concerned that you are an Indian citizen, we are not on those. We are on the only preliminary point whether you and the earlier proceeding is the same person. You are not supposed to disclose any defense. You have done earlier.
My lord.
If you are saying that you are the same person, I have been declared an Indian citizen, you are not again required to again face the proceeding. Not required at all. Only requirement is that you have to preliminary prove, have a preliminary satisfaction that proceeding and you are the same person. Only that part.
That we
You
have
are not
already,
supposed to disclose
my
anything
lord,
else.
we have taken in the taken the plea in the WS.
So how do you
and the
prove
petition.
it? So how do you prove
My
it?
lord, no, my lord, it's not required to prove, only to scrutinize the documents. The proof is
Mr.
one and
Sikdar,
same
Mr.
person,
Mr. Sikdar, you are on a different footing.
my lord.
We are not on the part of the documents that you are an Indian citizen. Those will not come here.
My
Then
lord,
what is the meaning of
my
red
lord,
judicata?
I contested the earlier proceeding, and by receiving the notice, second time notice, I have appeared
That
and
is what
saying that I am the earlier person.
that is what
Well,
you
that notice serving to same person repeatedly, that amounts to my lord, proof, my lord. That is, I think that is sufficient.
no.
And if
No,
required, my lord,
that is what you are supposed to do. You
The
stand in the witness box and you say you are the
tribunal,
same person.
my lord,
You can be cross-examined. If
my
it
lord,
appears that you are the same person.
then it will be full proof contesting proceeding. That is the abuse of process of court. That has been held by the Supreme Court in Saravanu case,
Let
Abdul
us see,
Quddus
let
case.
us see.
Yes, my lord. The paragraph 5, 9, 7 also.
Please, please.
Saravanu case, my lord, in the para 5, it is said, after the aforesaid order was passed, a fresh notice was issued on the 5th December 2018, thereby calling upon the petitioner to show cause that she is not a foreigner, illegal migrant. This notice, which was registered as FT case number so-and-so, was assailed by the appellant through writ petition number so-and-so. The High Court noticed that the appellant had suffered a proceeding earlier, which was resulting in final order in her favor, yet disposed of matter with an observation that the appellant may raise all the pleas before the tribunal in the subsequent proceeding. Paragraph 7. Learned counsel for the appellant has sought quashing of the subsequent proceeding on the ground that once the first proceeding culminated in her favor, the order passed in the first proceeding had attained finality. There was no justification to again subject the appellant to a fresh proceeding on the same ground. To buttress this submission, the reliance was placed on the decision of this court in Abdul Quddus versus Union of India, reported as 2019 6 SCC 604, wherein this court has observed in para 24 as under. Both the opinion of the tribunal and the order of the registering authority result in determination of right status under this statute and by an authority after a contest on merit, which would necessarily operate as a bar to subsequent proceeding before the same authority for redetermination of the same issue question. This court in Ujjam Bhai versus State of UP AIR 1962 Supreme Court 1621 has held that principles of res judicata equally apply to quasi-judicial bodies. Then, my lord, paragraph 9. We have considered the submission and perused the materials on record. Once it is not in dispute that on a previous reference, the tribunal, after giving opportunity to both sides on appraisal of evidence, found the appellant not a foreigner.
See. This is the background.
My lord.
It is not in dispute that it is the same person.
They have not raised any dispute, my lord. They have not raised any dispute, my lord.
Now, why is the second notice issued then? Let us see the second notice. 28.
Second notice, lordship will find at page 28. Isolated copy at 27. Here I am Jamiruddin Mullah, Anwar Mullah, Mahasara, village is same. As per the judgment, little variation of father's name written in the input order, only written as
Anwar.
Village is different.
No, my lord, same village.
Village is what?
Mohasara.
PS is Kusumara, one is Tarabari.
My lord, Tarabari, the Kasumara is subsequently created out of Tarabari. My lord. Therefore, my lord, it is also written in the vernacular. Tarabari, it was, there is a cut mark, then Kasumara. That means same village, same police station, my lord. Kasumara has been created out of Tarabari.
Yes, what do you say? There, huh? If it is against the same person, there is no, it's not longer res integra, the application of res judicata in proceedings of this
Yes,
nature.
yeah, yeah,
Abdul
yes,
Qudus
Lordship.
has
Yes.
settled the matter.
Yes, Lordship.
So the only question which you are trying to raise, whether he is the same person.
Same person.
But if you
Then
go
this
by
may
the,
be decided, Lordship, by the tribunal.
no. If there are materials
Yes.
to show that the present petitioner who has received notice at page 27 was the same person against whom the earlier opinion was given, then why is the
Then
requirement?
second reference is not required, Lordship.
That is it.
Yeah.
Till now, what have you said? Why did you issue a notice? There has to be some justification. If you come to the page 23, page 23.
My lord.
No, Mr. Sharma,
28.
23. First paragraph. Jamiruddin, son of Anwar, resident of village Pub Mohsora, PS Tarabari, Borpeta. Okay. And kindly come to page 26. The paragraph which starts after the first three lines. In this case, have you got?
Yes, yes.
In this case,
Opposite party has successfully.
and later on, he
proved
shifted to village Pub Mohsora, Tarabari, previous, Kosumara present. And the notice, present notice at page 27. Come to the vernacular at page 28. Jamiruddin Mullah, Anwar Mullah, Pub Mohsora, Onke, Kasumara. Yes, Mr. Sharma, you have to take instructions on this.
Yes, Lordship.
So we may not agree with Mr. Sigdar.
Yes, Lordship.
Regarding the procedure adopted.
Yes, yes.
If there is a dispute
Yes.
regarding the person, principles of res judicata application, there is no dispute, it's been
Yes, yes.
settled. But unlike a normal civil case, here a proceeding is against a proceedee, a noticee. And if the notice is different, we are not on the issues which have been determined between the parties.
Yes, Lordship.
Issues determination has attained finality,
Yes.
res judicata. But if the person is different,
Yes, Lordship.
you take specific instructions.
Yes, Lordship.
Heard 3A.R. Sigdar, learned counsel for the petitioner. Full stop. This court, wide order dated 27/8/2025, had granted time to the learned standing counsel to obtain instructions on the aspect of the matter which is on the plea of res judicata raised by the petitioner before the learned tribunal, and the tribunal, and the same had culminated
in the impugned order dated 26/20/25. When can you come back?
Lordship, 2 weeks.
Not 2 weeks. List on. Give a date. Today is 10th. We'll have it on 22nd. You get 1 whole week. Okay? 22nd of when is the next date?
My lord, I have no instruction, my lord, further proceeding may be.
8 October. 8 October is the next date. We'll have it before 8 October. is the next.
Let a copy of the decision maybe.
Copy of the given to you, perhaps no.
Yes, sir, if
Give
required,
an
you
extra,
can
give an extra.
serve again.
Please seek the Learned Counsel to serve, to furnish an extra copy of the written petition to Sri Sharma to facilitate him to obtain the instructions.
Soft দিলে হবে।
Soft copy আসেনি।
Soft দিলে হবে।
Soft দিলে হবে। That please. Improve order, my lord, Annexa 9 page 36 operating page.
Bye. The full door.
Second parameter.
Expert, you say?
Expert, my lord, I have submit WS, my lord. I did not submit evidence, my lord. On 7/4/2025. After receiving the notice, my lord, petitioner engaged legal aid counsel, my lord.
Thereafter?
Though my lord, petitioner submit all the relevant documents to the engaged counsel, but he did not submit evidence, my lord. So, my lord, one chance may be given, my lord.
Let us see the impugned order. Where, which page?
Let's see. Page 34 you will know.
Page from page 34, and except 9.
What is your explanation? What is your explanation? You are continuously absent.
Though my lord submit all the relevant documents to his engaged counsel, my lord, without any reason, he did not know, my lord.
Have you taken any action against the council?
No.
You are making such a grave allegation against the council.
Oh, my lord, as per instruction, my lord.
No, you are making, but have you taken any action? Have you filed a complaint into the Bar Council of India?
As per instruction, no.
Then
complaint
how
has
do
been
you,
filed.
it's difficult for us to accept. It may be a case, genuine case.
Only
but you
one
have to-
chance may be
You have
given.
to show your bona fide.
My lord,
It cannot be at your sweet will that you want to participate, we'll ask you to participate. Okay, we'll issue notice at this stage. Your, as of saying,
A.H. Chaudhary.
your A.H. Chaudhary, third A.H. Chaudhary, Learned Counsel for the petitioner who has put to challenge an order dated. You have not given the date of the order in your synopsis. Order dated 7/4/2025, passed by the learned so-and-so FT Tribunal, not in FT so-and-so. It is it is projected that the order by which the petitioner has been declared foreigner is an ex parte one, full stop. Para. It however appears that the petitioner had appeared before the learned tribunal and had also filed written statement. And the impugned order also reflects that the petitioner was absent continuously on 13/3/24, 9/4/24, and 4/7/24. And on the subsequent 2 dates, that is 15/10/24, subsequent 3 dates, 15/10/24, 3/3/25, and 29/3/2025, even steps were not taken. Full stop. The tribunal had accordingly proceeded with the matter. Full stop. Para. Let notice be issued, returnable by 6 weeks. The Union of India. Ask committee, 1, huh? This is it. Home Department, yes.
2, 4, and 6,
2, 4, and 6, G. Sharma. Election Commission of India. I am calling on behalf of Ms. P. Burwa. And who else? 5. Yes, P. Sharma, huh? Additional senior advocate. Okay, what is the status now? Where are you?
I'm outside, my lord. Till then, my lord, some protection may be.
You fail to appear. We'll see when some eventuality arises. Notice is also issued on the interim prayer. You take steps. After call for the record, call for the record of FT, registry to requisition the same. Yes, sir.
Lordship. Lordship, the contested case, my lord, is in order, my lord, page 77.
What is the IA for?
IA for the bail, my lord. The petitioner is behind the bar, my lord. And he's suffering from cancer, my lord.
The order is of which year?
2021, my lord. I have stated in paragraph number 8, my lordship, kindly see.
21.
Lordship, kindly see paragraph number 8, my lord. Kindly consider.
No, 21 we have to issue notice. On the first day we cannot.
And I'm suffering from the cancer, my lord, and the detention center also, my lord, taking care, my lord. And they have through them, my lord, I am.
You offer all medical facilities, Mr.
Medical
Sharma?
facilities by him.
Medical facilities.
Yes, Lord.
Provide to him.
Lord.
Heard. 3A Mubarak Learned Counsel for the petitioner who has put to challenge an order of opinion dated 1/4/2021, passed by the learned so-and-so in so-and-so. FT7 Borpeta or FT case number 998 of 2017. Full stop. Let notice be issued, returnable by 6 weeks. Union of India Committee 1, huh? Then 2, 4, 5, G. Sharma. 3, P. Sharma. And 6, M. Kolita on behalf of Ms. P. Barwa, Standing Counsel, Election Commission of India. Hey, call for the record, extra copies. The bail you write. Part 3A Mubarak Learned Counsel for the applicant, who by means of this application has prayed for release of the petitioner on bail. Full stop. It is submitted that the petitioner is suffering from serious ailment. Para, considering that the order put to challenge in the connected writ petition is of the year 2021, let notice be issued, returnable by 4 weeks. Again, one same, huh? One Union of India's scheme, I think. 2, 4, 5 G Sharma, 3 P Sharma, 6 M Kolita on behalf of P. Para, with regard to the ailment, comma, the Learned Council has drawn the attention of this court to the enclosures to the eye to show the seriousness for the para. Let specific instructions be taken on this issue. It is also provided that all necessary medical facilities be provided. No, it is also directed that the medical facilities be provided to the petitioner regarding the ailment.
Suffering from cancer, my lord. That is on the morning. And they have also informed my lord over telephone also, my lord, from the detention camp, my lord.
Which detention camp you are?
Matia,
Matia, Valpara.
Matia, lordship. From the detention camp, my lord, we have informed my lord. My
Okay,
lord.
then next, it will consider your bail application.
Lord.
Bring his present status.
He also,
Lordship,
also the.
I have already getting Lordship. I have received one letter, Lordship. Can I
What is
provide
it?
Lordship?
What is it?
With reference to the service cited above, I have honor to state that one DFN, namely Amjad Ali, aged about 45 years, son of Haja, resident of village Rumari Pathar, PS Tarabari, district Borpeta, was received from your police personnel on 29/5/2025 in connection with FT case number so and so dated so and so and admitted to this holding center. Since admission, he was found seriously ill and was undergoing treatment at GMCH Guwahati, where he has been diagnosed with a CA fluid of mouth in bracket WDSCC, which was earlier informed to Assam Police Border Headquarters, Srimantapur, Assam, hide this office WT message so and so. Today, that is on 30/2/25, this office has received a letter from the attending doctor of Assam Cancer Care Foundation under GMCS Guwahati regarding the medical condition of the said DFN. As per the letter, there is no further treatment possible at GMCH and the patient requires only palliative care. In view of this critical condition and in the absence of any family support here, I earnestly request you kindly to take necessary steps for release of DFN Amjad Ali from this holding center and to hand him over the family members if possible, so that he may receive the care and support.
This is by whom? Letter is by whom?
A letter from SP Holding Center,
You do one thing.
Gwalpara.
We'll have the bail application on Monday.
Yes, Lord.
Have this on record.
Lord.
And if that is the condition, if you already have no point 6 weeks, okay.
Yes, Lord.
Bail letter, this is an application so and so. Full stop. Sri, serious ailment ne ki asil. Also, Sri G Sharma Learned Council for the respondent so and so has, however, submitted that certain written instructions have been received, which written instructions would have been received, which would have a bearing in the adjudication of this IA. Fourth stop para. Let the IA let this case be listed on Monday for consideration of the IA. You have a copy of this?
Yes, Lord.
And submit it to your colleagues?
Yes, Lord.
Main hereditary to repetition to the piece of the and we said, I have to consultation. I will come on Monday. Yes.
Much.
May please your lordship. My lord, the improved order is at page 114. My lord, second round of writ petition, my lord. Earlier on January 23, there was a declaration he challenged in the writ petition. Writ petition was remanded to pass a fresh order considering the voter list of 1966 and 75. The learned tribunal has rejected again and declared him foreigner by impugned order. Lordship will find that page 114.
Okay, we'll pass the same order within 1 year. Same order, there will be some conditions imposed and need be released on bail. Are you in custody?
Not in custody.
Okay, then you have to appear and it will be released.
Will appear if direction is there.
Or respondent side open for now. Kali in order is na? Binay kuri logo. Union of India SK Committee 1. Then 2,
2, 4, 6,
2, 4. No, not 2, 4
and 6.
2, 4 and 6 G Sharma. 3 P Sharma. 5 M Kolita on behalf of. And M Islam. AIL Standing Council Election Commission of India. Rest will be sit.
My lord, to appear within how many?
10 days. 10 days.
Nibla.
My lord, this is an expiry order, your lordship. In the order it has been reflected, your lordship, that page 24 to 26, your lordship, that after filing of the written statement, your lordship, on 21/6/2018, so 75 days elapsed, your lordship, where the permissible period is, your lordship, as per law, 60 days, your lordship. So evidence could not be filed, your lordship.
But the impure order is 18.
18. Impure order is
Third. Is the item number? I have to A1 learned counsel for the petitioner who has put to challenge an order dated 13/8/2018 passed by the learned so and so in so and so. It is projected that the said order has been passed expertly by which the petitioner has been declared a foreigner. Let notice be issued, returnable by 6 weeks. Union of India. Committee 1, 2, 4
and
6 J Sharma, G Sharma, G 3 P Sharma, additional senior advocate, and 5 M Kolita on behalf of Miss P Borua, Standing Council Election Commission of India 5. Okay. Call for the records.
In this case, may I pray for lordship interim protection?
No, not fit.
You're coming after how many years?
That's correct, your lordship, but because husband and wife both have been declared to foreigners, that
We are not considered. If you come after so many years, how can you consider?
My lord, this matter may be taken up after some time by senior John Lex.
Records have come. You also filed an affidavit. Why? That's number 6.
Affidavit by ST.
2018 matter. Oh.
Any other? Next week.
Okay, after a while. You need to even key them around. Yeah.
May I please, Lordship, my senior as well engaged in this case newly, Lordship, and he is suffering from toothache, so may be taken after vacation.
Notice was issued on 21/8/2018, returnable by 3 months. Thereafter, it comes in 2025. Why? Three months becomes more than 3 years. It becomes 6 years. More than 6 years.
Yes, yes.
When can he come? When can Mr. Huda come?
Lordship, can it be after vacation?
No, after vacation, not before. So these are old matters.
Lordship.
We'll accommodate you if he is not well, but we cannot grant time till after vacation. 18 matters. A prayer for adjournment has been made on behalf of Sri and Huda.
Yeah.
Correct. Considering that this writ petition is pending since the year 2018, comma, while an adjournment is granted, comma, the same is directed, the case is directed to be listed on eighteenth of September, next Thursday.
Public.
None appears for the petitioner on call, whereas the respondents are represented. Para. This case is pending since the year 2018. And there is also an interim order in favor of the petitioner. Para. in the interest of justice, matter is adjourned to give the petitioner another opportunity to represent. Full stop. List after a week. It is made clear that in case of further non-representation, this court would pass appropriate orders.
May it please the lordship. My lord, in this case, my lord, petitioner once declared as not a foreigner, and subsequently, in another case, she was declared foreigner. So subsequent order is challenged before your lordship, and this is completely barred by res judicata, my lord. So, my lord, can you see the first judgment?
Sharma.
Lordship, can I go to the record? I don't have the file.
Record to them. Record to let you.
Indian Kitty has declared
2570.
24.
No, Sabo.
What do we say? They did declare this a foreigner. 18. My lord, page 51, annexure P10 is the earlier judgment whereby declared the petitioner as not a foreigner. Order dated 25/2017.
Let us see your written statement.
My lord, written statement is at page 55, my lord. Page 55, annexure P11. And in the written statement, my lord, in paragraph 20 and 21, she categorically stated that she was earlier declared as Indian, my lord. And the copy was also annexed. And it was in our evidence, it was exhibited also, my lord.
Is there any dispute with the identity of the person?
My lord.
Is there any dispute with the identity of the person?
No, my lord.
No
My lord,
dispute.
it is misinterpreted. Subsequent judgment, it is completely misinterpreted, my lord. The WS, in the WS, it is categorically stated that she is the daughter of so-and-so, 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 and judgment also annexed. But the subsequent order, my lord, it is reflected that she did not disclose the father's name and other relatives, and also not exhibited the judgment, my lord. This is completely, my lord, beyond record. And moreover, my lord, her father was examined as DW2. Her father's evidence was not discussed in the subsequent judgment, my lord. Not a whisper has been made.
No, we'll not go to the other evidence.
My
We
lord.
are not going to the merits.
My lord.
If you are banking your case on the principles of res judicata,
My lord.
we are only interested to know whether the proceeding in the earlier case and the proceeding of the present case
My lord.
is
Is
one
same-
and the same person.
Same person.
Is there any discussion?
My lord,
What is the discussion of the learned tribunal so far as your pleadings against paragraph 20 of the written statement is concerned?
my lord, the judgment, I will say, my lord, page 85, my lord.
Yes.
Page 85, paragraph 15 and 16, my lord. 16, paragraph 15, 16, 17. May I read, my lord?
Yes.
Coming to the second issue, OP referred one photostat copy of the judgment and order dated 25/2017 passed in FT case number 1812D/2010 marked as Annexer T along with the WS. OP simply adduced this Annexer T without any statement, and neither the said judgment has been exhibited nor filed any petition to recall the same. As to how this judgment and order dated 25/2017 is related to this reference proceeding. Be that it may, on perusal of the judgment and the order dated 25/2018 passed in FT case number so-and-so, Dubri case number so-and-so, shows that one Monwara Bibi, wife of Halim, previously residing at ward number 10, Vidyapara, PS Dubri, Assam, who is now presently residing in village Jalerpar Part 1, Dubri, Assam, is not a foreigner as alleged by the state in this reference case. As already noticed above, this tribunal, after evaluation and appreciation of the documentary evidence on record, came to the finding that OP has failed to establish her relationship with her parents by reliable and cogent evidence. As the OP had failed to establish the fact in issue that she is the daughter of Jamal Sheikh, the judgment and order dated 25/2017, whereby the Monwara Bibi was declared to be not a foreigner, does not have any relevancy in these proceedings. Then, my lord, however, the opinion rendered on 25/2017 in connection with FT case number 1812D/2010 by my learned predecessor member, FT number 1 Dubri, that Monwara Bibi, wife of Halim Khan, is not a foreigner. The present proceeding has placed this opinion in these proceedings as it will favorable to her. How it is, my lord, this interpretation? My lord, kindly see the WS, my lord, and the evidence of DW1. Page 61, my lord, paragraph 20 and 21 in the WS.
You have seen that?
And the evidence, my lord, evidence evidence 16, huh? Evidence, my lord, page 69, paragraph 16. Paragraph 16, my lord. Prior to receiving the notice of the present case, I have received notice in the FT case number 1810D/2010 from your honor, and I have contested the said case by filing written statement and submitting documents, etc. And the said case has been disposed of in my favor. Exhibit and certified copy of the judgment of FT case number so and so. Now the learned member held that certified copy has not been filed, my lord.
Yes, what do you say, Mr. Sharma?
Lordship, I need a little bit of accommodation tomorrow or day after tomorrow, Lordship.
Day after tomorrow is not possible.
Yes, Lordship. I don't have the copy, Lordship. I want to go through the.
But see, the identity as such is was not the issue before the tribunal.
Yes, Lordship.
The tribunal had proceeded on a different angle altogether. That the earlier opinion, though it may be in favor of the petition, all the facts have not been taken into consideration. Tribunal cannot sit over
Yes,
its
yes,
judgment.
Lordship.
My lord.
Yes, Lordship.
It's not a reviewing authority.
Order, Lordship, yes.
Neither is an appellate authority.
Yes, yes, Lordship.
If you would have come against that order,
Hmm.
got it set aside, matter would have been different. That order has attained finality.
Yes, yes. yes.
Now, the citizenship of the petitioner has been established
Yes.
now. And as per the latest judgment of the Honorable Supreme Court, the
Yes,
views were slightly different earlier. Now it has been settled.
Yes.
After Abdul Quddus.
Yes, Lord.
After there are some decision, my lord. Abdul Quddus is there one, then my lord Shital Mandal, then my lord latest is the Taravano Begum, Supreme Court.
Nothing on that. Law has been already settled, Lordship.
My lord.
I have nothing to say.
No,
in
but
respect
the
of that law.
records before us
Yes, Lordship.
may not require you to have, it will not make any difference unless you find out a case that the proceeding is a different person. That was not even the issue before the tribunal.
Yes, Lordship.
The tribunal would have decided on that issue that we have doubt whether that noticee was a different person. That is not the issue.
No.
Tribunal has gone with some other reasonings. Now, whether those grounds and reasonings are in consonance of the law laid down,
Yes.
it doesn't appear to be. That's good. We close it. No point of. We have checked. We checked the records. If there is anything, we won't find anything else.
Then Lordship, at two, Lordship.
Okay, at 2 o'clock. And those observations, that photocopy were given, not the certified copy, would have been relevant if by this time you would have come with some different
Yes,
allegation that this doesn't, those are not authentic or the person is different. Those are not your case. This is pending since when? This matter 2018. Okay, at 2 o'clock, then only to enable you to go by the records.
Yes.
Otherwise, we are closing it. 2 o'clock will be called, we'll call this for just his clarification. Otherwise, arguments are not required. You have those case laws.
Yes.
Give the list. May mark the paragraphs. It may not be a very elaborate order.
Where, please, my lord. Because if I have challenged the order 12/12/2018, my lord, page number 65, my lord. In this case also, my lord, true order is here, my lord.
Yes, what is your case?
My lord, in this case, actually, my lord, true order is here. Earlier also, one order passed by the IMDT 1994, my lord, where I was declared as an Indian. Now, my lord, foreigner court declare me as a foreigner. Only this point, my lord, I have declared a foreigner. The page number 68 of the order, my lord, this is a relevant part of the order, my lord. I have a voter list of 64, 70, etc. But may I read, my lord? Page 68, my lord, para number, next para.
Page 68.
Yes, my lord.
Yes.
Moving the exhibit documents, one file exhibit A is the
I find, not one, I find.
I file exhibit A is the xerox of the voter list of the 1965 in respect of the 70 Kolaigaon constituency. Here names appear as Dinesh, son of Bipin, age 33, and Romesh, son of Bipin, age 28, residents of Blaze, Balipara. Exhibit G is the computer printout of the voter details in the name of the Romesh, son of Bipin, residents of the village Balipara. Now question arises, if a OP was permanent residence of the village number 2 Singimari since 1950, how his name can be recorded at village Balipara? Why their name has not been appeared in the voter list of post 1965 and per 1997 voter list? What happened to his brothers Dinesh after 1965? Why his name did not appear in the voter list of the 1997, 2005, 2014, Exhibit B, C, and D, where still live or dead OP has filed to explain all this fact in his WS or his evidence. Okay, so come, my lord, after 70, my lord, I have come in the year of 50, along with my brother. As an Indian, we are residing in Balipara. That time we are residing in the Balipara. That's why the voter list of the 65 came the name with my brother. Brother names and my names is in the voter list of 1965. Thereafter 70 also, my brothers and my name is there. After 70, my lord, I have shifted my house to Singimari in the same PS, my lord. I have kindly perused my petitions, para number 4, my lord, 4 and 5, page 5, my lord. I have already stated there. Page 5, my lord. Para number 4. That the petitioner begs to state that in his WS, he has stated that he was migrated to India from the East Pakistan along with his elder brother Dinesh Devnath in the year of 1950, and thereafter they have resided at the Balipara village under Kolaigaon PS in Dorong district. After 1970, your petitioner has shifted in residing from the Balipara in Singimari village and the residents there permanently. His name has been recorded in NRC. He has got his legacy data where his name has been shown in Romesh and Bipin. So, my lord, after 70, I have come to Singimari in the same PS. My brother remained in Balipara. So, after 70's voter list, my names come in separately in the Singimari and my brother's is there. Learned Court says that why my name is not coming with my brother in other voter lists. All the voter lists I have annexed.
Let us see the voters list.
Pardon?
Let us see the voters list.
Voter list is already annexed, my lord.
Where page?
Page number 22 is the 65, my lord.
Page 22.
Yes, my lord. That is the list of 1965, my lord. Dinesh and Romesh, my lord. Dinesh, my elder brother, my lord.
Let us see the vernacular at 23.
My lord, thereafter, my lord,
Let us see the vernacular at page 23.
23, my lord.
Vernacular copy.
Yes, my lord. Page number 23, my lord.
Your name is Dinesh?
Yes, my lord. No, my lord, my name is Ramesh, my lord. Dinesh, my elder brother, my lord. Thereafter, my lord, page 24, my lord, 1970 brutalist, my lord. Vernacular, my lord, page 26, my lord.
ইনফর্মকে ডকুমেন্ট দিছে কিন্তু আইএমডিতে রিপিট ইঞ্জিন ডিক্লেয়ার করার কারণে তো হয়ে গেছে
Thereafter, my lord, page 27, my lord, that is the 1993, my lord.
And 29, vernacular 29.
Yes, my lord.
1993.
Here, my lord, my wife name is there. My elder brother's name is not there because I have already shifted to the Singimari village, my lord, and residing there, my lord. In the same PS, my lord.
And this 70 to 93, what had happened?
My lord.
1970 to 1993.
1970, after 1970 to 73, the rural list is not produced to me, my lord. No, already continuously I have reside there, thereafter also.
No, 70 to 93 is a pretty long period.
Yes, my lord.
How many years? 23 years.
Yes, ma'am.
23 years, where were you in this 23 years?
Already I am residing there, my lord, Singimari, my lord.
Yes, thereafter?
Thereafter, my lord, 2005, my lord, that is page 30, my lord. Vernacular 32, page 32, my lord.
Restore the board differences agent. 93 was 55, 2005 is 57. This is
Yes, Mr. Modi. Well, thereafter, my lord, 2014 list is here. Accordingly, I have cast my vote in the year of 18 also. On the other hand, my lord, page number 44, my lord, I was taking one training from the military, my lord. That is, certificate was issued by the major, military major in the year of 2005, in the year of 50, my lord. Kindly peruse the page number 44, my lord. Sorry, my lord, certificate was issued 24/3/2060, my lord. Page 44, my lord.
Where do you get the date?
Date, my lord, in the right side, my lord, that is the, and was this discharged on 24/3/2060, my lord. In the last form, second line, my lord, in the right side of the certificate, my lord. My lord, my humble submission before this court, my lord, already I have come
This
before.
annexure L was exhibited.
My lord.
This annexure L was exhibited.
Yes.
Was it proved?
No, here advocate, already I have annexed, my lord. Earlier, this document was not annexed. At the time of trial, my lord, he has not annexed this document.
This will not have any bearing in this writ proceeding. We are only examining the decision-making process. This certificate was not before the tribunal, so this cannot be a relevant aspect before us.
And also, my lord, I have come before in the year of 50, my lord, before 1771.
Yes.
My lord, all along in the year of 1950, my lord, I am residing in the India, my lord. So the Honorable Court declare me that after 71 I have come here. So that's why declare in 25/3/71. So the sufficient documents I have, my lord, already I have produced before this court, my lord. I have reside here. I got the NRC also. I have got this voter I card and everything, my lord. And residing permanently in India, my lord, since 1950, my lord.
What is your submission on the earlier proceeding, IMDT?
And the WS is there, my lord, only page number 12, my lord, my WS, my lord.
No, regarding the earlier proceeding before the IMDT.
IMDT already order is there, my lord, page number 45, my lord. Same document there also I have an exhibited, my lord.
Yes, what do you say, Mr. Pine?
Well, first of all, with regard to the IMDT reference, with regard to the IMDT opinion, there is the opinion of IMDT, because that may come into play. That is settled by the Honorable Court, by full bench of the Honorable Court. I'd like to point out that point also.
Please have your seat.
This is 2014 4 GLJ 604, my lord. And 2014 3 GLT 500.
Same.
Yes, same. 2014 3 GLT 500.
3 GLT.
Yes. Is 500.
Name?
This is, my lord, the Anwar Ali versus State of Assam.
This is on the IMDT previous opinion.
Yes, yes, yes.
It will not be binding precedent.
Yes, my lord, that will not be binding precedent.
It will not be a res judicata kind of a
Yes.
thing.
In fact, it is said, my lord, the para 33 is simply para 32, 33. I'm reading the 33 part, my lord.
Yes. Please read.
Similar would be the position in respect of those cases where the tribunal constituted under IMDT Act had dismissed the references seeking declaration of notices as illegal migrants. That means dismiss the references made by the policeman. Since those references were decided by the tribunal on the basis of the provisions of the IMDT Act and the IMDT rules, which have been observed by Apex Court to have shielded the illegal migrants rather than facilitating their detection and deportation, and thus declared unconstitutional. It will be open to the state in all such cases to proceed against those persons afresh under the provision of this Act of 1946 and Order 1964. So there is, it is open here. So there is no bar for the state to proceed again. That position is there. Now then we have to look, Melody, on merit. Whether merit is. Malad, it is admitted position. He admitted that he come, Malad, prior to 1973. He admitted that he came from Malad, East Pakistan. That is admitted position. There is no this. Now, when did he come? Whether he was continuously residing after coming to State of Assam, because Section 6, Malad A3 provides that if he comes prior to 1966 or Malad 66, 7, in between 66, he has to continually reside in State of Assam. Then only he will get the benefit of 6C. Because in other states, 6A is not applicable. Other states, 6A is not applicable. But to get 6A benefit, he will have to continuously reside in the State of Assam. That has to be proved. There are judgment of this honorable court also, which says, apart from his coming in between this period and that period, he has to prove that he is continuously.
Continuous stay is also necessary requirement.
Yes, yes. Continuous stay is necessary.
Yes.
That has to prove. Now, the only document he has relied is the 1955 voter list.
First is 65.
65 voter list. That is, one Dinesh and Ramesh is a voter. Dinesh and Ramesh is a voter. And he is claiming to be this Ramesh one, my lord. And this is a Balipara village.
Correct.
This is a Balipara village, and one Ramesh, son of Bipin, is a voter here, aged about 28 years. So if it is so, his age will be sometime, his date of birth will be sometime in 1937. His date of birth will be sometime in 1937. Now the next document is, my lord, after 1965, next document is 1963 voter list.
Not 60, 70.
Oh, so, 93 voter list.
No, 70 he has given.
70, it is not probably annexed, my lord.
Yes. It's 26.
It was not exhibited. 70, it was not exhibited before the tribunal, my lord.
Page 26.
70 was not exhibited before the tribunal.
You have not exhibited this.
70 is
I
not
think
exhibited.
not there.
Not exhibited. So exhibited documents, net exhibited documents is 1993 voter list.
Here is the video. 12, 12, 9, 12, 12, 18. 12, 12, please work it. Service. Page 26. Please borrow. And this is on the regular basis. Before the result. Yes.
Next voter list, my lord, document is 1993 voter list, my lord. That is, this is in a different village. This is in a different village. This is in Singimari. Earlier one was, my lord, this Balipara. This is now at Singimari. And
Singrimari.
Yes, Singimari. Singrimari.
Singrimari.
Yes. Here he is aged about 55 years. It's consistent to 1960. My lord.
65.
55. 65. The village is different.
Father's name?
Father name is same. Bipin.
Bipin.
Yes. Now the issue is from 1965 to 1993, the existence of the petitioner in the state of Assam is not proved. If this on the basis of these two documents. That is the simple point, my lord. Other aspect, my lord, your lordship, if your lordship see 2005, then 2014 voter lists were submitted, but there is huge
Those will not be relevant.
not relevant, and those are huge contradiction of age. 10 years.
Yes.
10
Those will be not relevant. We will not go by.
Yes.
We will go by the voter list of those particular years.
Yes. So
If he's more than 80, then his own voter list, if he was less than a particular age, then parents and the linkage with the parents. That is what we normally do.
Yes. So if he could bring some evidence in between this period that and if he can, my lord, it is also to be seen whether the same person, Dinesh son of Bipin and Ramesh son of Bipin and Ramesh Devnath son of Bipin there in 1993 is the same in one person or not. Because they are in a different village and there is no record in between 1966 to 65 to 1993.
But you see the addresses. Addresses are the same.
Addresses village is different, madam. Balipara in
No,
1965.
The problem is that
Golaigaon.
1970 has not.
Yes, 1970 has not an I cannot. 1970 is not exhibited, madam.
But in 1970, the village was Balipara Bagisa.
Maybe, madam.
Honda number 178.
That 1993, my lord, even though 1971 come into play, if we can accept also, then if it is in Balipara, then 1965 and my lord 70 is consistent. 71 is consistent. In that case, there is no see. Only issue after 1971.
That IMDT is started.
1980.
Contested.
Contested.
So in 1994, again 1994 is there.
Yes.
Contesting that matter at least.
Contesting that matter.
So 70 to 90 is something which is missing.
I don't know when, my lord, if we accept that, my lord, the certified copy of the IMDT.
What does the record say? IMDT.
I'm sorry for the question. This is equal to separate casing.
Order to be declared.
Only the IMDT order is the next, my lord. IMDT record is not called.
No, no, the order is a certified copy.
Yes.
Give it the.
Compressor, IMDT.
Who is the proceeding there? Who is the notice is there? Can you just?
Ramesh
accept it?
Depna, Ramesh Depna.
Son of?
Son of Bipin Chandra Depna. Singimari Bagisa. He is Kaligaon, district Torang, opposite. This process initiated in 1990, my lord.
And the opinion is of what?
Opinion of 1994.
94.
Yes. This proceeding started in inquiry started in 1988. Ended, my lord, the process ended on 1994. So up to 88, if we can.
Inquiry of 88.
Yes, SP inquiry of 88. 88 to 94. 88 is, if we accept this, he is there. At Singimari village, Singimari Bagisa.
Statement of 16 of the In the written statement, was the aspect of shifting stated, was it proved in his evidence?
Evidence he has not proved that aspect.
Because the learned tribunal has gone to the aspect that where has the brother suddenly gone from the voters list.
Evidence in page 64. Progress page box.
That aspect is missing, my lord.
Which aspect?
Shifting aspect.
Shifting, there is no specific.
Statement, there is no
There is no
statement.
specific, but
There-
there is only one statement at page 13 towards the last part. in support, last sentence, third last line from at page 13, in support.
Yes.
In support of his claim for citizenship, the opposite party furnished with written statement, certified copy electoral roll, 1965 Lok Sabha of village Balipara.
Yes, only that must mean that this is, there is no explanation how he has come from Balipara to Singrimari. That statement is not there. Statement is that my name is appearing there in the Kalaigaon and Balipara. Then again statement that my name is appearing in the Singrimari. In how he has come to Singrimari, why his name is appearing in the Singrimari, that is not there. Either in the WS, nor in the WS, neither in the WS, nor in the evidence.
Regarding the requirement of continuous stay, can you show us that provision 6A?
Yes.
Yeah,
Citizenship Act, Maru.
You're having this book, Mr. Pai?
Yes, yes.
Which page?
Page 7, Maru.
7. Six A three.
Yes. 683. Subject to provision of 6.7, every person in Indian origin who came to Assam on or after 1st January 19, but before 25th of March 1971 from a specific territory and has since the date of his entry to Assam has ordinary resident in Assam, that is Chairman, and since the date of his entry into Assam, been ordinary resident in Assam has been detected to be foreigner, shall register.
Yes, but this is after 66 to 71.
Yes, ma'am.
He's
My lord,
relying upon
my lord
voter list
means
of 65.
682, my lord.
682.
Subject to the provision of section 6, subsection 6, all persons of Indian origin who come before the 1st day of January 1966.
Ordinary resident.
Yes.
682.
Yes, 682.
Ordinary.
That's
Yes, anything?
My lord, my humble submission report is closed. My lord, kindly set aside the impugn that order, my lord.
Thank you. Response, sample.
All right.
May I please, Lordships? My lord, we have challenged the order dated 36/2018, page 53. Now, kindly see page 55, bottom. Specify bottom. The opposite party neither produced any death certificate of her father nor produced any voter list of her father after 1989. The DW2, that is brother of the opposite party, there is a vast age discrepancy as like as father of the OP, hence the nationality of DW2 is doubtful, and as such the evidence of DW2 is not taken into consideration. Now, my lord, my submission is this, that so many voter lists we have already annexed. That is the voter list of 1966, page 17 of my father. 17. 17. Oburuddin is my father. So, I am drawing your lordship's attention. 1966 voter list, page 17. In the name of my father, Oburuddin. Then 1970 voter list, page 19. Then, my lord, voter list of 1977, page 21. 1970, page 19. 19. Oburuddin. Yes, it is page 19, or 40%, page 20. No, Oburuddin Sheikh is there. No. Father. Oburuddin. Family is written by, yes, it is written by authority. What can I do, my lord? So this is their mistake, my lord. It is computer generated voter list. So both are female. That one female has married another female. So this appears so. So that lordship may kindly see. And again, my lord, kindly see page 21, 1977 voter list of my father. Page 21 of my lord. Oburuddin in 66, 21 years. And 17. 17. Yes, that is 69 years. No, kindly see the address. That is a raisable question, but thing is this, my lord, such sorts of age differences, name differences are common in these cases because the enumerators are responsible for that, my lord. Lordship is aware about the case of Abdul Mutali, 2010. 2010, it is Abdul Mutali's case. No, 2015. 2015. And another case is also there, my lord. That is, yes, 2015 to GLT 617. It is also division bench judgment, my lord. Here, it is said that a difference of ages between among these persons cannot be taken so seriously because they are rustic. Difference is there, my lord, I admit. That is, I cannot raise. That is true, my lord, but it is there. But my name is there. I am coming out of another very interesting thing is there, my lord. Your lordship may kindly have a look to reference, page 11 of the LCR. So in this manner, lordship would see, as gap is there, I understand that, and that is on record, I cannot deny it. Your lordship will take this consideration, considering the status of these people, and judgment of that is Abdul Mutali, as well as another one who was what? Supreme Court project. So, there is also a judgment of Supreme Court that is no, not sure. That is then 1989 voter list is there, my lord. 89 voter list of my parents is there. Page 23. 21, yes, 77. Yeah, no, I am daughter of Apuruddin. Yes. Apuruddin is my father. So then lordship would say 89. There is also my father's name. That, my lord, I do not have. Yes, so it is only written like this, that he was born and brought up at village Jhograpar. Jhograpar. So that is not clear, but in the voter list with her husband, after marriage, that lordship may kindly see page 27. Page 24 is the voter list of 89. Yes. Apuruddin Sheikh. Yes. Samed Ali is my husband. It appears so, but it appears so. But here, lordship would see her age is written as 19. Similarly, 97 voter list, my father's name is also there. And 1997, page 27. Page 27, 1997, this is Obiron Bibi, wife of Samed Ali. So, here her age is written as 22 years. because my marriage was solemnized before inserting my name in the voter list. So that's why my lord, with my father is not there. But my brother has adduced evidence. But the learned tribunal said that there is age difference, so that is not taken into consideration. But what is the age difference, that is not discussed. Hello, that is very important thing. I will show the judgment of our High Court. No age difference, he has taken that. My lord? No, that is not there because at that time whether this person was, maybe, but it was not exhibited. 1997 it is exhibited, but with husband. 97, well, that is page 25. Yes. Operative person, page 26. No, I may not be there because it is my father. With my father, there is no voter list. With my husband, page 27.
Yes, 27.
27.
This is extra copy. He was there, so certified copy was not provided.
Not certified because the letter D, kindly see page 28, serial number 464. Letter D is there. When D is there, certified copies are not provided. But Lordship should believe this because these are common, so many persons' name are there. And that is also not their case that it is duplicate or it is fraudulently obtained. That is so, as the letter D, so certified copy was not provided. Only reason is that. Then Lordship would see the voter list of what voter list it was? You have to go. 2010, my lord. Operative person, page 30, Somed Ali, my husband. Pagla Bibi. Pagla Bibi, perhaps. Pagli Beva. That means Beva means after death of husband. Hajiran, na? Hajiran Bibi. Hajiran Bibi. Aburuddin. 17 now. Fajiran Bibi, page 24. So many voter lists are exhibited by law. Now the learned court says after 89, no voter lists have been exhibited. My submission is that what documents we have submitted, those documents are not considered, but what is not submitted, the learned tribunal is on that. A large number of voter lists is not necessary. If genuine documents are few genuine documents are there, that is enough. And most important thing is this, my lord. My brother, whose name lordship may kindly see, page 49. Mujibur Rahman. He has given long evidence, my lord. Page 49, kindly see. Yes. Yes. Might be they have filed a petition, thereafter it was removed. That might be. And what was at that time, accordingly, we have submitted. At that time, there was accordingly, we have exhibited, we have submitted here the same said copy. But when it was there, so we have got the certificate copy, we have exhibited.
The parents house. And Adavari factory, it was D. In Adavari factory. So it was continued in the parents house. That's a husband's house. Adavari factory.
One clarification, my lords.
And my difficulty is I participate when they want me to participate, otherwise I cannot. If once your lordships want, then I have to. No, I've got a matter in single bench. I was just finding out what is the status of the agreement. There is a because in the cause in the cause it is written if time permits. My lord.
How you like it? May I start? My lord, may kindly see page 43. Some question was pushed to us, answer is here. Page 43, 43. Para 2. That after marriage, OP and her husband temporarily stay at her father's house at village Jhograpar part 4, where the name of OP father Apuruddin, Sheikh OP's mother, Fajiran Bibi, OP's husband Sumaid Ali, and OP herself, Obiran Bibi, were recorded in the voter list of 1989. So, the reason was that after marriage she was for some time in the father's house. So their names were recorded in the voter list of 89 in her father's house. And important thing is this, always Jhograpar. Village is always geographer. Now, regarding the now Lordship may kindly see page 39. My brother adduced evidence in my WS. WS page 38, operative portion page 39. Para 9 Lordships may kindly see that the name of office father Opuruddin Sheikh, brother Mujibur Rahman, and Sojibur Rahman, along with other family members, were recorded in the voter list of 2013 at village Jograpar 4, part 4, under Common House number 426, serial number so and so respectively, printed copy. Now, this Mujibur Rahman is DW2. So, in my WS, his name is there much earlier than adducing evidence. So, the queries were Lordship said, and that's why the D was at Adabari. That means after marriage, I was for some time in my father's house. Always there is my father's name, mother's name, etc. But when we shifted to village Adabari, then the D letter was inserted. This is the reason. D letter was inserted, but thereafter it was clarified and our names were regularly appearing in the voters list, subsequent voter list. So these are the reasons. Now, regarding my lord, I want to draw your lordship to certain citations. Here, it is our High Court's decision. Here, reference is given Abdul Mutali's case, I have given. And Muslim Mundar's case is also given reference. Sirajul Haq, that the Sirajul Haq, my lord, that is the differences of names and ages cannot be a ground that he will be a foreigner, he or she will be a foreigner. So Sirajul Haq's case, Abdul Mutali's case, all are there. Here now, Lordship, 2021,
4 GLT 664.
4 GLT 664. 2021, 4 GLT 664. Para 19, Lordship may kindly see. Page 19. The impugned order of tribunal also does not refer to the evidence adduced on behalf of the proceeding petitioner, as has been held by the apex court in 19. 19. Married man. The impugned order of tribunal also does not refer to the evidences adduced on behalf of the proceeding petitioner, as has been held by the apex court in Dol Govinda Paricha Supra in respect of section 50 of the Evidence Act, that there are 3 essential requirements to section 50 of the Evidence Act. Namely, there must be a case where the court has to form an opinion as to the relationship of one person to another. In such a case, the opinion expressed by conduct as to the existence of such relationship is a relevant fact. but the person whose opinion expressed by conduct is relevant must be a person who, as a member of the family or otherwise, has special means of knowledge on the particular subject of relationship. In other words, the person must fulfill the condition laid down in the latter part of the section. Now, Lordship, here Lordship would say, my father is Oburuddin, and with Oburuddin, my name also appears after marriage. In the same house, same family with my husband, where I stayed for some time after marriage. So, this ratio of this case is fully applicable in my case. Then Lordship would kindly say, para 21 of the same judgment. 20 is also relevant, but I am reading the most relevant portion. 21, under the circumstances, we find that documents exhibited and the oral evidences adduced by the petitioner before the tribunal have not been considered by the tribunal, and no reasons are discernible in the impugned order so as to enable this court to appreciate the basis of rejection of these evidences by the tribunal. Under the circumstances, we are constrained to interfere with the impugned order dated so-and-so passed by FT Kamrup M, 2nd Guwahati 3 in FT case number so-and-so, and remand the matter back to the tribunal to hear the same again and arrive at a judicious finding on the basis of proper evaluation and appreciation of the evidences presented before the foreigners tribunal. Now, it is the word has been used as judicious finding or appreciation. So here, one thing has been said by the learned tribunal that there are as differences, so I am not considering that. Only this part. But what is the difference of this is the relationship when a person is in the same roof and their names are there, those things are not discussed. Since 89 voter list, his father's name is not given, but what I have given, that is not properly discussed. So, Lordship would see this judgment is fully applicable in my case. And my lord, the second judgment I am referring 2021 3 GLT 12 para 3 and 3, 7 and 11. 7, 11 is most important. 7 I am reading. So 2021 3 GLT 12 para 7 and 11. Seven. Reference was made in terms of the direction of this court referred to above by the Superintendent of Police B. Baksa, file letter number so-and-so. In the said letter, the Superintendent of Police Baksa, however, mentioned that an inquiry has been conducted, and having gone through the inquiry report and a scrutiny of the inquiry report and document submitted by the petitioner, it was found that the opposite party petitioner seems not to be an illegal migrant. However, still, the Superintendent of Police Baksa proceeded to refer the case to the Foreigners Tribunal for favor of opinion. The aforesaid referral letter is also crucial for proper decision. Accordingly, the same is reproduced below. Here, Lordship will see how this judgment is applicable in my case. Can you see the reference? Page 11. Record, LCR record. Page 11. And please turn over the page. In the left side, a favorable report was given in my matter by a police officer, but that is cut. Who has cut this, I don't know. Para 11 and next page. Just opposite of that page. Now, Lordship would say the favorable opinion was given by an inquiry officer in my favor, but that is cut. I don't know why it is cut. That is very important and doubtful on the part of the prosecution, because this is their record. And 12 maybe is in my 12. Completely, except few lines, others are completely vacant. Reference is totally vacant. Page 12 can listen. So, my lord, they are trying to make me a foreigner, and this is the quality of their investigation, inquiry, and conduct. Now here, my lord, now Lordship, I have para 11 kindly see, para 11 of that judgment. We also like to observe that the investigation or reference cannot be mechanical for the simple reason that it is the legal basis for conferring jurisdiction to the Petitioner's Tribunal to give its opinion as to whether any person is a foreigner or not. In that context, investigation and reference assume great significance. So here, my lord, the case of Muslim Mandal is also there. The reference should not be mechanical. The referral authority must apply its mind in a proper manner. So that is the reference. Kindly see, that is the reference. Is it a reference? If I say that they want, by hook or crook, they want to make me foreigner, perhaps I would be not in wrong. Reference is saying this. And this para 11 also, the second part, para 11, as a corollary, if no proper investigation or reference is met, it may vitiate the entire subsequent proceedings taken up by the Foreigners Tribunal if the investigation does not indicate that a concerned person under investigation is not a foreigner or does not appear to be a foreigner. We fail to understand how a reference can be made concerning that person unless there are additional materials available on record to create a doubt about the citizenship of a person. In this regard, we would like to refer to the observation made by this court in the state of Assam and others versus Muslim Mandal and others. They referred to 2013 1 GLT 809, which read as follows. So what I have said that the crux of this observation is that should not be mechanical. Authority must apply its mind, because you are trying to you are referring the matter of a foreigner who claims to be a citizen. This is very important matter. I am claiming, no, I am Indian citizen, but they want to say, no, you are not Indian. So in this context, there must be very heavier proof that my claim is not justified and their claim is justified. Now, the justification would not be on orally, that it shall be reflected in the reference, but it is not there. Another judgment, Lordship may kindly note down, 2021 5 GLT 320 para 11, 12, and 17. Para 11 I am reading. Thus it goes without saying that the tribunal is to give opinion only on the basis of the reference so made. In view of the provisions of Section 6A of the Citizenship Act 1955, the reference can be made only on the following circumstances. If a foreigner enters India between 1166 and before 25,371, now my lord, when so these are the second categories of citizens, 66 to 71. Before 71, that is, there is no dispute, but here 66 to 71. So every document, including NRC of 51, say that I am in the soil of India before 1166. The court is then observing in para 12. However, in respect of persons who had entered in India after 25/3/1971, and as such reference is generally made as regards the status of a person with reference to the aforesaid period of entry during 1166 and 25/3/1971 in Assam from a specified territory, or whether entered after the aforesaid period. As far as those who have entered before 1966, there is no requirement for determining the citizenship as Section 6A2 itself provides. So, my lord, this is a case. The principle of law is this, that the person has been taken on consideration that whether he is a foreigner or not. Now, it shall be looked into by the learned tribunal on the basis of the reference made by the SP border. Now, the quality of the reference, Lordship has seen, and my documents have been also seen, and my brother's name is there in WS, and he has evidence. Learned tribunal said that as there is as differences, so I am not considering the matter. This is not the law. What is the difference in as? What is the difference in how he has disbelieved? Only know you are a bad man. That is not enough. We must bring some elements by showing that he is a bad man because he is doing this illegal, unlawful activity, etc., etc. So, my lord, only claiming that the person is not a citizen is not enough, but you should have come with clean hands. And it is also the Section 9 is very wrongfully used in this matter. Section 9 does not relieve the prosecution. There are judgments of the Supreme Court also. Does not relieve the prosecution from proving his case. If your lordship, perhaps lordship is not delivering the judgment today, there are several judgments. Section 9 of Foreigners Act and Section 106 of Evidence Act are the same. So, it has been elaborately discussed by the Honorable Apex Court that the burden of proof does not mean that prosecution shall be relieved from its burden of proving the case. They shall have to, minimum prima facie, they shall have to prove that no, this is the case. So, minimum prima facie, what is the nature, quality, I have already drawn your lordship's attention. So, in this regard, my lord, so referral authority has not applied mind at all, or applied but in a wrong manner. So my humble prayer is this: on the basis of all these documents, the conduct of the prosecution investigation and their references, and non-believing my brother's witness, whose name is in WS itself from the very beginning, before adducing evidence, and NRC from 1951 till the last voters list we have made 2017 made. So my name appears either this way or that way. That means in father's house, thereafter after husband's house. Only 1 year there was the because of shifting the evidence. That is why, my lord, normally, yes. 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 Page 24. The 23 I have seen, that is the voter list of 89. Sorry, that he is my husband. No, 2010 not itself. Page 27 can you see it is 1997. D, Lordship, one thing, may draw Lordship attention. It will be Lordship would see, I see Adabari High School, Adabari. Now, in same Adabari, next voter list, there is no D. 2010. Yes, yes. 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 Obedient will be similar. Also, they have not annexed with the, but in WS it is said. It is said. WS. Page 38, 38. Create a party person, what your lordship has desired to know, that lordship may kindly see para 10 afterwards. Para 8 first kindly see. That the name of his father Upuruddin Sheikh and brother Fajibur Rahman were recorded in the voter list of 1997 of 23 Dhubri LSC at village Jhagrapar, part 4, under common house number so-and-so, Annex C. Then that the name of his father Upuruddin Sheikh, brother Fajibur Rahman, Mujibur Rahman, and Sojibur Rahman, along with other family members, were recorded in the voter list of 2013 of 23 Dhubri LSC at village Jhagrapar, part 4, under common house number so-and-so, serial number so-and-so, respectively. So, Api's father died in the year 2016, and after death of Api's father, the name of Api's brothers, namely Fajibur Rahman, Mujibur Rahman, and Sojibur Rahman, along with other family members, are recorded as regular and registered voter, and they had obtained electoral photo ID card from the Election Commission of India issued by the ERO under 23 Dhubri LSC. So, my lord, it is there. Then 11, the OP got married with one Samed Ali, son of Farjullah Sheikh of village Adabari, part 2, under PSN district Dhubri, Assam, where the name of OP and her said husband were recorded in the voter list of 1997, and OP was wrongly identified. Sorry. 89 is not there, my lord. 97 is there. No, my name is not there, but my no, it is true that my name is not there, but my father's name is there. So, my lord, what is there? It is there. my lord. Beyond that, I cannot travel. Now, my prayer is only this: the prosecution has not conducted the case. One important thing, Lordship, I have given the judgment already, the 2021 5 GLT 320. Well, Lordship has, yeah. Paragraph 17, Roman 3. This is very important. The Foreigners Tribunal cannot go beyond the term of reference. Now there is no reference. So in this count alone, the case is liable to be admitted, allowed, and at best it may be remanded. That is up to your lordship discretion. But my prayer would be they tried to make me a foreigner but failed. Legally they have failed. So we are sitting in a place which is the place of law. So in this view, when the tribunal cannot go beyond reference, there is no reference. This is sufficient to allow the writ petition. My lord, one submission, my lord. Actually, I have another important matter at court number 15. So my argument is concluded. My argument is concluded. Last submission is that which was in my favor. A police officer wrote down that my father's name appears so and so. He also took evidence. He said that he did not doubt me, but that is cut. There is a serious doubt and reference is nil. So that is enough for my case. Other things I have already narrated. If your lordship is not delivering the judgment today, then I may give you one or two, three execution shall have also proved the case prima facie. Burden honor shifts to them also. But they have cross-examined my brother but at the time of delivery of order, that is discarded. Yes, tomorrow I will. Today, so I am going, my junior will be here, my lord. But that before the person, I am saying one thing. By oral submission, the written documents cannot be discarded. Obliged.
Yes, Lordship. My humble submission is that there is no infirmity in the opinion passed by the learned tribunal, Lordship, and learned tribunal passed the opinion on the basis of materials available on record, Lordship. And Lordship, these are the references registered at the time of IMDT, Lordship, and after the judgment of Sarvananda Sonowal, Lordship, all the pending cases before the IMDT, Lordship, those are transferred to the a concerned foreigners tribunal constituted under Foreigners Tribunal Order 1964, Lordship. And Lordship, regarding enquiry part, Lordship, what Aziz Mia case says, Lordship, and para 11, I am relying, Lordship, WPC 2370/2023, 2370 WPC 2370/2023. My senior colleague has argued in respect of enquiry, Lordship, regarding some enquiry has been made in favor of the proceeding, Lordship. And regarding that, I am submitting, Lordship. After discussing, Lordship, clause 2 of the Foreigners Tribunal Order in previous paragraph 10, Lordship, paragraph 11, Lordship, I am reading. A reading of the provisions of clause 2 of the Foreigners Tribunal Order 1964 as indicated above also leads to conclusion that the report of the investigating authority that may have been submitted as to whether the suspected person is a foreigner or not would be merely indicative in nature and cannot be said to have attained finality on the status of suspected person as to whether he is a foreigner. From such point of view, we are unable to accept the submission of Mr. R. Ali, learned counsel for the petitioner, that as because the inquiring authority in the instant case had given a report that the petitioner is not a foreigner, therefore the superintendent of police border did not have any jurisdiction to make a reference to the tribunal for an opinion as to whether he is a citizen or not, and accordingly reference itself made is a defective reference which is required to be returned back, Lordship. So, Lordship, here in this case, Lordship, enquiry officer's report, Lordship, cannot attain finality, Lordship. This is the proposition, Lordship. And after that, Lordship, here in this case, Lordship, proceeding has to establish her link with her projected father, whose name appeared in the voter list of 1966, Lordship. But in this case, proceeding totally failed to establish her link in respect of her projected father, namely Opruddin Sheikh, whose name reflected in the 1966 voter list. Although, Lordship, her name reflected along with his father in 1989 voter list, but persons by which he want to link, that name is not there. One Samet Ali is there, but Prosidi wants to link with Abaruddin Sheikh or Apruddin Sheikh, Lordship. So that cannot be taken as link document of Prosidi, Lordship. And regarding voter list, Lordship, I am again Yeah, please. Yeah, please. Again, Lordship, regarding voter list, I again want to rely the judgment of Aziz Mia's case, Lordship. Para 14. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with the further materials acceptable in law. Yes, Lordship. And then Lordship, here in this case also, Lordship, there is only link, he is only relying on the school certificate as a link document and oral evidence of his projected brother, Lordship. Nothing apart from that. And Lordship, school certificate. Yes, Lordship. I think Lordship, his younger brother. At the time of giving evidence, his age was 36 years. Yes, in the year of 2018. Yes. And during filing of this petition, Lordship, he was 42 years, younger brother, Lordship. Mujibur Rahman, Lordship, who deposed before the tribunal. Mujibur Rahman is at the time of deposition, Lordship, her age was 36. So in 2018, so her date of birth in the year of 1982. Lordship, in WS Lordship, he has stated that Lordship. Procedural BB. Mother's name. In yes, in page 49 Lordship. 49. Yeah, brother of the proceeding. Mother's name is Fujiran Bibi in WS page 38 Lordship para 4. Lordship. Then Lordship, first time coming to oral evidence of the brother Lordship. Or Lordship, before giving evidence, brother has to establish his link with his projected father. Lordship, there is no link at all, Lordship. Although in WS Lordship, he has made a specific statement in para 10 of the WS Lordship that his father died in the year of 2016, but after 1997 Lordship, after 1989, they relied on the voter list of 1997. Then Lordship, after 1997, the father is not visible in any of the voter list Lordship. And their specific statement in the WS that Lordship, his father died in the year of 2016. But his projected brothers who deposed before the tribunal during deposition, her age was 36 years. So he sometimes born in the year 1982, and his first voting right should be in the year of 2000. So after 2000 Lordship, not a single voter list of his projected brother has been placed before the tribunal, along with his projected father Lordship. So that in absence of link with his projected father, that oral evidence cannot be accepted as a valid piece of evidence, Lordship. And law has been already settled that oral evidence without support of documentary evidence is not acceptable in law. And Lordship, next, Lordship, a school certificate. It was school certificate dated 30/10/2017 and issued on 30/10/2017, but proceeded left the school on 31/12/1987. So after 32 years, Lordship, she get this certificate after leaving of the school. So Lordship, regarding belated issuance of school certificate, what Supreme Court as well as our High Court has said, Lordship. In Supreme Court, Lordship, I am relying on Rafiqul Haq's case, Lordship, a criminal appeal number 2686 of 2025. Criminal appeal number 2686 of 2025 arising out of SLP criminal number 5598 of 2019, decided on 19/5/2025. Para 15. Lordship, Rafiqul Haq, ROFIQUL HOQUE versus Union of India and others. Criminal appeal number 2686 of 2025. Decided on 19/5/2025. Para 15, I am just reading. The tribunal as well as the High Court have considered these documents and have found that those earlier voter lists relate to a person located in the some other village than the one of which the appellant claimed to be a resident. In such circumstances, the appellant ought to have stated in his affidavit or demonstrated by some documentary evidence that his ancestors had migrated from that village to the other village where the appellant was reported to be residing. But according to the tribunal, there was no such claim by the appellant in his affidavit. Therefore, the tribunal discarded the probative value of those voter list entries. Interestingly, this part, Lordship, the school living certificate on which heavy reliance was placed by the appellant was also doubted as there appeared no reason for it to have been obtained 10 years after passing from the institution. Moreover, the headmaster of the school was not called for to prove the authenticity of the certificate which duplicate was produced. For the foregoing reasons, the tribunal and High Court held that the appellant could not discharge his burden proving that he is not a foreigner. In the view taken by them cannot be held perverse or manifestly erroneous, unreasonable as to warrant interference under Article 136 of the Constitution of India. Lordship. Regarding belated issuance of school certificate, what our High Court has said. Yes, Lord. Yes, Lordship. Apart from these two documents, Lordship, there is nothing to prove her linkage with her projected father, Lordship. If those are gone, Lordship, nothing remains, Lordship. And another important aspect, Lordship, regarding name and age discrepancy, petitioner relies on the Abdul Matali's case, and Lordship, this was distinguished by this honorable court. In the case of Basiran BV, 2018 1 GLT 372, regarding name and age discrepancy, Lordship. 2018 1 GLT 372, I think, para 30. 2018 1 GLT 372. May I read, Lordship? Reliance placed in the case of Abdul Matali alias Matlab Muhammad Supra can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decisions did not lay down any law and was a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voters list, which the petitioner contended were not her creation, being entered into by officials of election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner herself. to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voters list which are in favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. This is probably that marks only. Proceed.
Lordship. Bye. God bless.
Okay, here in this case, marriage was solemnized also on 13/3/2019. That should have been recorded by a magistrate also, a statement. Also. That's correct also, but FIR was not registered. FIR. Marriage is not yet dissolved, Lordship, because marriage is not yet dissolved. She is my legally married wife, lawful wife. Lordship, in my humble submission, she is in illegal captivity, Lordship. Lordship, in my humble submission, that is not an affidavit, that is merely. Because the page 70 in my humble submission have no evidentiary value, Lordship. No legal value, Lordship. It is page 17. It would have been a different thing, Lordship, had it been recorded by a magistrate. We shall leave out it to approach the approach. Gotcha.
HK Hazard. HK. Lordship.
and the objective that the rate of levels focus was not for the power of the report, including the related case is that the wife of the petitioner is an illegal has been forcefully taken away by the phone numbers.
Six also.
Six. And we in their active. The petitioner has however annexed a communication period 6/9/2025 issued by wife of the petitioner that she on her own volition has gone out of the state of under those facts and circumstances found the aspect as to whether a rate of readiness purpose to be bad or not would be itself given in the system. As regards the other part of the resolution regarding action on the part of the police on the FIR something with also the petition from a knowledge also. Well, the other Supreme Court, I was in the other Supreme Court, and including the case of Sakari versus has at this stage, we perfectly developed complicated petition. Having that you do this petition. But for the word, there would be a petition in the money, and then we will be much more.
Because I had a small IA which I had moved, there was a correction of a writ petition number passed in an order by this court on the 25th of January 2023 by Justice Buzar Barua as he was then, where the writ petition number was written as WPC 4369 of 2019, where it ought to have been WPC 4369 of 2017. So it was. There was an office note which placed it before my lords for correction. $33 million. $33 million. IA Civil 309 of 2023. So the Joint Registrar Judicial and Deputy Registrar bench put up a note, my lord. In page 8 is the order, my lord, which at para 2, line 2, it mentions the WPC as 4369 of 2019. And again in para 4, it says that WPC 4369 of 2019 recalled, writ petition restored to file and to be listed, but it should be 2017, my lord. Just a typographical error, my lord, overlooked. Connected records is review. My lord, it should be 17, my lord. Writ petition. Review petition number 118 of
Like. Deeply obliged.
May I please Lordship, item number 38. Hello.
I have seen, my lord, but case of inquiry was different. Otherwise, lordship, pleadings are almost same, lordship. Pleadings are almost same. But lordship, whether that person and this persons are same or not, that has to be a certain lordship.
My lord, in the two judgments, there is a photograph of the petitioner, my lord. Same photograph, my lord. Easily, it can be easily identify, my lord, the person.
Lucia.
Husband's name, father's name, address, everything is correct.
Plastic surgery করে recently.
Well,
Lordship, item number 38 already 3 times left over there. And consideration of bail, my. This year, my lord. And there is a there lordship only for. And court already passed order after receipt of that this better will consider.